Hello, viewers. In our continuing discussion on intellectual property laws, Subhadra and I will be discussing all about copyright laws in India in this edition of Tête-à-Tête.
Thanks, Sandhya, for this introduction. Today is, as you mentioned, it's about copyrights, which we are going to discuss. So, what is this copyright actually, and what is the meaning? So, let me just get to the basics first. So, copyright means it is a legal right which is given to creators of literary, dramatic, musical, sound recordings, artistic work, and cinematographic films. Basically, copyright is a bundle of rights which is given to any person who falls under the creative aspect or creating something using the following which I had mentioned before.
Right.
So, simply put, it means a right to copy which rests only with the original creator.
Correct.
Suppose if I have created a work, then I am the copyright owner, I am the first owner. What happens then is everyone else must seek permission from the original creator to use or reproduce the work. For example, what are these literary works which we are talking about? It is nothing but simple novels, storybooks, concept notes which we sometimes write down during our meetings, lectures, research papers, comic books, even Kindle or ebooks, any kind of ebooks, poems. Yeah. Brochures also get into this. I think a lot of companies have brochures, so even brochures can be copyrighted, and also translation work. So all these things form the part of what we call or describe as the literary work, which is falls under the copyright. The other thing, which is the dramatic work, which is a play. It can be a performance. It can be a recitation. It can be a choreography. All these things fall under dramatic work. So it is choreography, especially for dances, even during performances. If there is a particular bit which is being done, even that can be copyrighted. Next, we go on to the musical work, which I think most of them and most of the debates happen in copyright is today around the musical work, which is any sound, which is any sound recording, which is audible. It does not include lyrics of a song or a sound made by human voice, which is like, for example, like a jingle or something or anything which is audible gets into this musical work. Next, what is sound recording? Any sound, including human voice, whether it is a song, whether it is a speech, whether it can be a recital, it can be podcasts, all these things gets into sound recording. So it is not to do with any music or anything, but verbally speaking, any speeches which you give or any podcast, as I mentioned before, all these things go into the bracket of sound recording.
Right.
Next is artistic work. What are these artistic work which we are talking about? Cartoons, caricatures, comic strips, designs, paintings, sculptures, architectural works, all these fall under the bracket of artistic work. The last one also is cinematographic film, which includes audios, videos, and any visual content. For instance, a movie which has pictures as well as songs, basically anything to do with movies.
Right.
Live performances, broadcasting rights. So all these things fall under the protection of copyrights, and basically any work in tangible form which can be seen, read, heard is also subject to copyright.
Copyright, right. As with every law, the first question is, why do we need to register under a copyright law? Is there a necessity? What is the need for registration under copyright law? Now we'll take the example. I can explain with the help of an example. Say a painter. He has made a beautiful painting. Now he is the original owner or the creator of the said painting. He has the right to benefit. He can either sell it to art patrons, or he can hold exhibitions and sell it, or he can display it somewhere. That is his right. But in the meantime, if let's say a photographer comes and takes pictures of those paintings and makes copies or digital copies and sells it everywhere, unnecessarily the photographer benefits, while the original creator doesn't. Therefore, it is necessary to register under the copyright. simply because it protects the owner, the original owner or the original creator. The truth is, it is not mandatory to register under copyright. However, for the reason of offering protection of the original owner, his rights, it is suggested to register under the Copyright Act.
Absolutely. So this will also add credibility in legal action against infringement.
Yes, absolutely.
So now we are going to talk about what are the laws which are governing copyrights in India. In India, the Copyrights Act 1957 governs the copyright of works. Besides, internationally, it is governed by the Berne Convention and the TRIPS Agreement, which is the trade-related aspects of intellectual property rights. Another interesting aspect which I wanted to discuss is also about the scope of the Copyright Act. Always there is confusions between what is and what can be copyrighted, like the idea or an expression. So today we are going to discuss on this about idea versus expression. Now, the copyright law is entirely based on the premise of protecting the expression and not the idea. Ideas can be generated by all of us, but the whole intention is how we express the idea only can be protected and not the idea as such. For example, say the 7 basic musical notes we have, sa, re, ga, ma, pa, da, ni, which is in a classical music. Now, each musician may compose music with these 7 notes as a base. Therefore, the same 7 notes are present in every music composition.
Exactly.
The songs are but different. The songs are the expression which are entitled for protection under the copyright. So the 7 musical notes cannot be exclusive use of any person. So I think it makes it very clear that idea cannot be copyrighted, but the way you express it can be copyrighted.
Yes.
For example, similarly, if you have, say, 2 authors and they can have the same idea, but it is the way they express themselves by writing and projecting that story is what is protected. There has been only one landmark case in India on distinction between idea and expression, and this is a very, very old case. It is by the Supreme Court. And the case is called as the R.J. Anand versus Deluxe Films. It is a 1978 case.
Right.
In this case, what happens is Mr. Anand is a playwright, produced a theatre play based on the theme of nationalism. So thereafter, there is one Mr. Sehgal, who is from the Deluxe Film production. He requests for a copy of this play to see if he could make a movie out of it. But after this had happened, nothing had taken place concrete after Mr. Anand had handed over this play. However, after a couple of years later, Deluxe Film produced a movie. Now, Mr. Anand found it to be based on the play which he had shared, but no credit was given to him at all. So, Mr. Anand filed a case with the trial court, which ruled that though he is an owner of the copyright, there was no infringement as such when this movie had come out with the theme of nationalism. Because the theme is common, nationalism, and the movie was different. The way it was projected was different from the way Mr. Anand had penned down his play. Right. So the way the movie was taken was nothing like the play. So Mr. Anand appealed to the Delhi High Court, which also upheld the trial court order. And on a special level petition in the Supreme Court also upheld the judgment passed by the lower courts, clearly stating that though the idea was the same, the narrative was entirely different. So this was a very thin line between the idea and the expression was clearly established. Right. So from a layman point of view, if you see, if the reader or if a viewer gets a clear opinion that subsequent work is being identical or it is a copy of the original work, then it will only amount to copyright infringement.
Right.
So if only a theme or an idea is same, but it is presentedly entirely different, then it does not amount to any copyright infringement at all. So from a layman's point of view, if either the reader or if a viewer gets a clear opinion that the subsequent work is either identical or it is a copy of the original work, then only it amounts to copyright infringement. If only say a theme or an idea is same, but when it is presented completely different, it does not amount to copyright infringement. Adding on to what you had mentioned, public knowledge, domain, or information that is commonly known cannot be copyrighted.
Correct.
So the blueprints drawn out by an architect, the architect's idea translates into his expressing as a blueprint. Now, this can be also registered under the copyright. However, there are certain common elements to make architectural drawings or blueprints, which is like the lines, textures, colors, scales, etc. That cannot be registered under the copyright exclusively for one person or an entity.
Subhadra, you spoke about what are all the items that can be registered under the Copyright Act, and also the fact that there is a distinction between idea versus expression, which brings us to the next topic about what are those which are outside the purview of the Copyright Act, what need not be copyrighted. So I'm going to take you from your idea versus expression, where you had mentioned that it's the expression which is copyrighted and not the idea. But several times one sees that the idea and the expression are the same. It is very difficult to distinguish or separate them. In such circumstances, courts will apply something called the doctrine of merger or the merger doctrine principle. I will explain with an example. For instance, mathematical problems. Now, we all know that the basic mathematical principles are the same. So if you are going to exhibit it or put it down as a problem, a question and an answer and solve it, there aren't too many ways of doing it. There's only one or maximum two ways of solving a mathematical problem. So in that case, the idea and the expression are not vastly different. In fact, there's not even a thin line. There's no difference at all. In such cases, those cases will be outside the purview of being registered under the Copyright Act. In fact, there's a case law I'd like to read. Chancellor Masters of Oxford versus Narendra Publishers. So Oxford was a publishing house, as all of us know. They had brought out a book on mathematical problems and principles. A couple of years later, they find that one of the publishers, by name Narendra Publishers, have actually brought it out as guidebooks, where they have verbatim copied the mathematical problems with the solutions. So in the court, what was debated was that all publications, the mathematical problems and the way of solving them is the same. So it will not amount to infringement simply because the idea as well as the expression of the idea, which is a mathematical problem, is the same. So courts did rule that it is not an infringement. So in such cases, such situations, they are outside the purview of the Copyright Act. Adding on to what you said, I would also like to mention that obviously ingredients cannot be copyrighted. Like that, domain names, pen names, pseudonames, standalone letters, alphabets, themes of a contest, because such contests are conducted by different people, organizations. So the contests or their themes, the rules and regulations in the contest sheet, they all cannot be copyrighted. Similarly, slogans and phrases, catchphrases, one-liners cannot be copyrighted because they'll be registered under the Trademarks Act. Like that, color combinations or letters written in a certain font or color cannot be copyrighted.
Right.
We now have to discuss, by registering under the copyright, what rights are provided to the original owner. So I would like to broadly categorize the rights as economic rights and moral rights. So we look at economic rights first. Economic rights will include right of reproduction, right of exhibition, right of communication in any way making it the work known to the rest of the world, a performance or a performance presentation, and a translation or an adaptation. And this is across a literary work or a dramatic work or a sound recording or anything like that.
Now, coming on to the other right, which is the moral right, So what does this moral right have? It has the right to paternity, that is the right to be. It is owned with you. The original author or the owner has the right, and he's the owner. And right to the integrity, which is right to the privacy of his work, and also right to prevent from copying of this original work from not letting anybody else to copy the original work. And also one more interesting aspect here is once an original work is created, there cannot be any alterations or there cannot be any changes or additions or edits made to the original work. Even once when it is given, even with permission to someone, the person who's got the permission cannot alter or change or edit. It may be even, say, for example, a photograph is being taken by a photographer. Say there are about 3 people holding hands together, and there is a sculptor who likes this photograph. He takes it. He says, I would like to make it with permission. He takes it. He likes to make it converted into a sculpture. So as he is making a sculpture, what he does is he makes an addition, say a little bit of a dog sitting on a lap or something. That cannot be done. That kind of an addition in somebody else's original work, even once it's been done in another format, like from a photograph turned into a sculpture or a sculpture turned into a painting, whatsoever may be, you cannot make any revisions, additions, or deletes. That is a very, very important aspect when it comes with the moral right. And of course, you are the sole first owner of the work which is being created.
Right. While with the economic rights, I would like to mention one thing. We had discussed about performance right as an economic right. But I would like to bring it to the notice of our viewers that the performance right is an automatic right only for the original owner of the copyright or the original creator of the work. Anybody else wants to perform, they have to take a prior permission or pay royalty or something to prevent it from amounting to infringement. In fact, a much publicized case way back in 2016 with famous singer SPB and music director Ilayaraja was just this. With the music director saying that the original ownership of the work belongs to the music director and all the singers must take prior permission. So performance right is an automatic right only for the original owner of the work.
Correct.
So, Bhadra, what is the term of a copyright once it is registered?
So in the case of copyright, it is protected during the lifetime of the creator. And in case of the original works, it is lifetime of the original creator and for about 60 years from the year following the year of death or the original author.
Right.
Now, for the posthumous work, when the original task is being published and after the death of the owner or the creator, it is considered as posthumous work. And the duration of this copyright in such case shall be for the term of 60 years from the date of publication after death.
Right.
Now, coming on to the films, sound recordings, etc., it is for a period of 60 years from the date of publication of the film or the sound recording.
So 60 years is common. Yeah.
Yes, it is common and it is quite a long period as well.
Yes.
Copyright for designs are for a period of 60 years or until 50 times of reproduction of any item using such design.
When it comes to designs, there seems to be a dichotomy because the definition of a design features under the Copyright Act. There is also a Designs Act of 2000. Now, for our viewers' benefit, how do we know under what to register a design?
See, under the Copyright Act, the term design is defined as any artistic work.
Right.
And if you see that artistic work in the sense, if you're going to pen down any work of art, if it can be a sketch, it can be black and white, it can be color. Say, for example, I'm going to sketch for say for a fashion house, a design, I'm going to bring in something. So when it is that going to be on paper or in any other format, electrical format or whatsoever, it will go into the aspect of designs under the copyright. You can, anything which is on the format where you can sketch it and do things like that.
It's a form of expression.
Yeah, absolutely. Now, when it comes with Designs Act, when can you register under the Designs Act? Now, under the Designs Act, it clearly says it can be colors, it can be textures, it can be lines, it can be various scenes which are put together, or a combination of these, which will be showcased on an end product or an article, and that can be in either 2D format or a 3D format. Now, for example, I have made the sketch for a, say for example, say for a salwar kameez, for example. I've sketched out the pattern, how it is going to be. And now what I'm going to do is I'm going to represent it or create that entire piece, that whole piece when it is being finished. And if there is a very different aspect, or if I'm going to use, say, for example, hand sewn fully salwar kameez, or it is going to be a combination of hand sewn with some, say, sewing machines are used. I'm going to add some kind of very different hand sewn laces or some kind of, unique aspects which are going to get into that salwar kameez as such. And it's going to be created as a whole piece. That whole piece can be registered under the Design Act, which is the end product.
Right.
It is not anywhere in between which you can register under the Design Act. Only when it is completely showcased as a final end product, that end product can be get into the Designs Act.
Okay. Subhadra, I'm curious to know, can a recipe be copyrighted?
No, Sandhya, recipes cannot be copyrighted because they just merely list out the ingredients. So these ingredients cannot be copyrighted. It is, of course, your own idea which is coming out and you create. Though a lot of people think recipes can be copyrighted, but when the recipes are combined together and made as a book, that as a literary work can be copyrighted. Say, for example, there are a lot of good cooks today. Like, for example, the immediate name is Malika, Malika Badrinath, who comes into my mind. So she is like, she's got a whole lot of recipes, but her recipes individually cannot be copyrighted. But once it is made into a book format, that can be copyrighted.
Okay. We'll now look at the aspect of infringement of a copyright. Now, a copyright is said to be infringed, or a copyrighted work is said to be infringed when any person other than the original creator or owner uses that work without prior permission or payment of royalty, or is not even assigned the work. So the key aspect here to be noted is that there has to be a prior permission. Now, the point to be noted here is if prior permission is obtained, or if a license is given, or if the original owner assigns the use of copyright to another person, then it will not amount to infringement. Now, typically when you say it is either a permission, obviously it's a prior permission in the form of a written consent, or there will be payment of consideration, royalty, or giving credit for a work, or mentioning in the credits, that sort of thing happens. In that case, it will not amount to infringement. However, one has to note that just by giving a credit will not say that permission has been given. Obtaining prior permission is mandatory.
Correct. Similarly, use of work for fair dealing will not be considered as infringement. Fair dealing means the use or reproduction of the work in course of any judicial proceedings. For example, if there is an evidence or something has to be given in judicial proceedings, if we have to use a work, then that is not considered as infringement. Or for review or for research purposes, it will not be considered as infringement. So there are a lot of cases where reviews have been done for research purposes where the same documents will be also looked into. And those aspects and all, it is never considered as an infringement. And use of any non-commercial, educational and research purposes. That's what I meant. And Section 52 of this Act clearly contains an exhaustive list of what is not considered to be as infringement.
Right. An often asked question is whether plagiarism amounts to copyright infringement. Your views?
Now, plagiarism is when one person passes off the work of another as his own. Whereas copyright infringement is when one person uses the work of another without getting the approval from the original owner of the copyright. It is very common to see nowadays on social media handles people putting the clippings of newly released movies or the songs or albums, recording movies in the theater on mobile phones, making CDs out of them, selling it is outright copyright infringement, besides attracting the anti-piracy laws as well.
As you had mentioned about streaming movies illegally or on mobile phones, I would also like to add here about music companies. See, music companies
Absolutely.
are the owners of the rights relating to a music. So when music streaming apps actually start streaming it on their apps without getting prior permission or license to use from the music companies, then it amounts to infringement. Right?
Yeah.
So the best and fair practice is to get prior permission or license from the original copyright owner to use his or her work.
Correct.
We'll now look at the remedies that are provided under the Copyrights Act. There are both civil remedies as well as other remedies. Civil remedies mainly being permanent injunction or asking the wrongdoer to do or the copyright infringer to pay damages, compensation,
Yeah.
including legal fees or reimbursing costs of court cases and legal costs. What are the other remedies, which are also, it just does not stop with civil remedies. There are other remedies which include imprisonments, fines, or a combination of both.
A word of caution here, while creating any original work, whether it is a song, penning down lyrics, whether it is a painting or you're recording, it is always suggested to ensure that the sentiments of the society in general shall not be hurt or offended. For example, let us recall the case against the internationally recognized artist, Mr. M.F. Hussain.
Right.
So a section of the society, perceived that some of his paintings were offended to certain national and religious sentiments, and some of his paintings contained nude depiction of gods and goddesses. Such kinds of things which are going to raise controversies should be avoided.
Correct. Absolutely. Very well said. So these are the main aspects that we have covered under the Copyrights Law and Act. Now, we all have to know that the copyrights law, both in India and internationally, is dynamic and it is ever evolving, keeping pace with the changing technology, especially with the digital world that we are in today. However, the main objective of law remains the same. That is encouraging creativity, enabling economic gain, and ensuring that a balance between the original creativity is actually used for the larger good of the society. We hope our viewers have, been able to get some basic knowledge about the copyrights. And we'd like to say a big thanks to all of them. And we'll meet again in the next episode. Thank you.
Thank you so much.